I want to thank all of you for being here today. One of the things I wanted to follow up on when Secretary Johnson testified in 2014 about the crisis we were facing from unaccompanied children from Central America, one of the things he recommended at the time, in fact, when he testified before the Senate Appropriations Committee, and I recall hearing him say this, I think it was before this committee as well, he talked about the differences in the law between countries that are contiguous to the United States of America and countries that are not contiguous to the United States of America. And he said that in terms of changing the law, we're asking for the ability to treat unaccompanied kids from a Central American country the same way as from contiguous countries. And it would help if the Senate amended the law for children to treat the children the same from a non-contiguous country as a contiguous country. So as I understand it, the law is different if it's a child from Mexico, for example, that comes to the border in terms of what rights and legal explanations can be given that they can voluntarily return, and that cannot happen with a Central American country. Is that true? And when you talk about steps we could take to help this situation, isn't that one of the steps we could take, consistent with what Secretary Johnson told us at the time of this crisis? Whoever is the best person to answer that.
Senator, that is my understanding of the TVPRA as well. I know operationally, the Border Patrol, when they encounter either Mexican national or Canadian national, they can work collaboratively through their local repatriation agreements to assure for children who wish to withdraw their application and return voluntarily, they work collaboratively with those respective governments to ensure the safe return of those children. And to the Secretary's point that if we had that flexibility with other countries, for those children who at the time of encounter by CBP, whether it's Border Patrol or at the ports of entry, if they wish to withdraw their application and return to their country, we have outstanding repatriation agreements with those countries. We have many opportunities to effect that repatriation in a safe and humane manner. And given the opportunity, we would be able to exercise, a broader spectrum ability for those children who are not seeking any kind of protection.
And I understand that this law was put in place, I believe, when President Bush was in office, in which we were treating the contiguous countries differently than the non-contiguous. But it seems to me that it's outlived its purpose and that you should be given the same tools as the Secretary had previously asked us. So is this a tool that you would still like to have, Mr. Miller?
Yes, ma'am. We support the Secretary's effort to, have broad spectrum ability to do the best thing in the interest of the children that we encounter.
Very good, thanks. I also wanted to point out when Senator Peters had asked all of you about the relationship between, for example, the President's executive orders and DACA and the influx of unaccompanied children. At the time, and I recalled this as well when we were dealing with the real influx, Secretary Johnson made actually a point of being very clear with the Central American countries, because clearly there was an impression, regardless of how they got the impression, but there was clearly an impression at the time that somehow you could receive a permiso or pass if you made it to the United States. And I know that he clearly said he wanted them to understand that the children would not benefit from the President's DACA order. And so this clearly was some contributing factor in the sense that there was an impression or a misimpression in Central America, or the children were being given a misimpression by perhaps the coyotes or other folks that were trying to make money off of them in bringing them here. And so would you agree with me that that was a piece of, because certainly the Secretary addressed it at the time and had concerns about it?
Yes, ma'am. Our colleagues from CBP and their kind of post-interdiction interviews, we're well aware that that was a marketing strategy of the smuggling organizations, and I think the Secretary worked extensively both in, to educate and to inform that that was not the case, that there were not permisos, and that persons who were interdicted after January 1st of 2014, throughout their immigration court proceedings, throughout the life cycle, as we call it, of the immigration process, they would retain that date of interdiction and thus remain a priority.
Do you think that's been clearly communicated now so that that is not being conveyed, or do you think that's still a concern that that's being misrepresented in those countries?
To the best of my knowledge from our colleagues in the State Department, that that message has been received, and it seems to have contributed to the reduction in the influx this year.
Thank you all.